Here's the latest update from the legal trenches in the fight over concealed carry bans, and it's a big one. The Department of Justice, along with Attorney General Bondi, just made it official. They've jumped into the fray, backing those who are challenging the widespread restrictions on concealed carry that are now climbing their way to the United States Supreme Court. One of the most aggressive opponents here? The state of Hawaii, and they're not pulling any punches. They've submitted a formal response, and, to nobody's surprise, they want the High Court to back off. Hawaii is particularly outraged that the federal government under the Trump administration decided to weigh in at all. Let's walk through what just happened, especially for folks stuck in anti-gun strongholds like California, New York, and Hawaii, states that are bending over backward to make legal carry next to impossible. If you've been following the legal fight post-Bruin, you know the Ninth Circuit has been hearing several challenges to new laws crafted to sidestep that ruling. These laws try to sneak concealed carry bans in through technical loopholes. One of the big ones was California's Senate Bill 2. Another is Hawaii's near-total ban on public carry. Right now, the centerpiece of this fight is Wolf versus Lopez, a case that targets Hawaii's new restrictions and is knocking at the Supreme Court's door, asking for a review. At the heart of the case is a lower court decision to deny an injunction, basically saying it's perfectly fine under the Second Amendment to outlaw carrying a firearm on most public property. Yes, you heard that right. The Ninth Circuit gave its blessing to a law that bans carry almost everywhere, despite Bruin making it crystal clear that the right to bear arms doesn't stop at your front porch. Now here's where it gets interesting and encouraging. The Department of Justice under the Trump administration, along with Attorney General Bondi, filed an amicus brief asking the Supreme Court to take the case right away under emergency review. Their message was loud and clear. It's time for the Supreme Court to slap down these lower courts for blatantly ignoring what Bruin said. Their filing didn't just stop at carry laws either. They touched on so-called assault weapon bans and magazine limits, showing strong support for the broader Second Amendment fight. For those of us in the firearms world, that was a breath of fresh air. It's not every day you see the Department of Justice standing shoulder to shoulder with legal gun owners. But of course, Hawaii didn't take it well. In their latest filing, they basically told the Supreme Court to disregard what the federal government had to say, accusing them of butting in where they don't belong. So what's the actual issue on the table here? In response to Bruin, Hawaii passed a new batch of carry laws, but instead of following the spirit of the ruling, they created even more roadblocks. Under this new scheme, you can't legally carry on private property unless the owner posts a clear sign giving you permission. And the same rule applies to publicly accessible places like grocery stores, malls, parking lots, and retail giants like Walmart and Target. In short, if the sign's not there, you're banned from carrying. Here's the real kicker. Even if you somehow manage to navigate Hawaii's brutal permit process and actually get approved, that license is close to useless. The list of prohibited carry zones is so long that the average person has nowhere left to lawfully carry for self-defense. It flies in the face of Bruin, which struck down the old May issue laws that let local officials decide whether you deserved a permit. Before Bruin, Hawaii's permitting process was infamously restrictive. According to a Ninth Circuit report from back in 2018, only 4 concealed carry permits had been issued to private citizens in the span of 18 years. In one entire county, they hadn't approved a single one, ever. But Bruin changed everything. The Supreme Court made it clear. The right to bear arms extends beyond your home, and the government cannot demand you prove some special need in order to exercise that right. May issue systems were declared unconstitutional, period. Now here we are, Hawaii digging in its heels to defend its freshly inked carry bans, and the federal government stepping in on the side of individual liberty. The High Court hasn't yet said whether it'll hear Wolf versus Lopez, but if it does, we could be looking at another major decision, one that might hammer home, once and for all, that the Second Amendment means exactly what it says. After the game-changing Bruin ruling, Hawaii responded by rolling out Act 52, legislation that was supposed to bring their gun laws in line with the Supreme Court's guidance. But rather than reforming a broken system, Hawaii doubled down and made the process even tougher, much like what we've seen in other anti-gun strongholds. In response, a group of plaintiffs, backed by multiple pro-Second Amendment legal foundations, filed suit, challenging the new carry restrictions as unconstitutional. At first, they saw some success. A federal district judge granted them a temporary restraining order, which was later upgraded to a preliminary injunction. The court found that Hawaii's rule, which prohibited carrying a firearm on privately owned property open to the public without clear, affirmative permission from the owner, likely violated the Second Amendment, especially when measured against the standards set by Bruin. Unsurprisingly, Hawaii appealed, and the case moved up to the Ninth Circuit Court of Appeals. And in a move that won't shock anyone familiar with the Ninth's track record, the court sided with the state. They upheld Hawaii's sweeping carry ban, which applies to all types of private property open to public foot traffic. Think retail stores, parking lots, grocery chains, and malls. The legal justification they leaned on? Let's just say it raised more than a few eyebrows. The Ninth Circuit cited outdated statutes, including niche hunting laws and even historically racist restrictions, to support Hawaii's overreach. This kind of selective use of history has become a pattern in anti-Second Amendment rulings. But it's especially problematic, given that Bruin emphasized a faithful historical tradition as the core test. Following that defeat, the plaintiffs sought an en banc review, asking a larger panel of Ninth Circuit judges to take another look. That request was denied. Still, a few judges, like Judge Van Dyke, openly voiced serious concern with the court's refusal to revisit what many consider a deeply flawed decision. But for folks who've watched the Ninth Circuit sidestep the Second Amendment time and time again, this was par for the course. With no other option, the plaintiffs brought their case to the highest court in the land, asking the United States Supreme Court to take the case under emergency review. The core question now: whether a state can legally forbid licensed citizens from carrying firearms on publicly accessible private property, like grocery stores or shopping centers, unless those owners post signs granting explicit permission. It's worth noting that this case is still in what's called the interlocutory stage, meaning it hasn't been fully resolved in the lower courts yet. Normally, the Supreme Court stays out of these early phase appeals, especially when it comes to Second Amendment matters. But something unexpected happened. The Department of Justice, the Trump-era Attorney General's office, and several federal-level legal advocates filed amicus curiae briefs supporting the plaintiffs. They urged the Supreme Court to get involved immediately. In their brief, they made it clear: Hawaii's near-total ban on carry is directly at odds with the text, history, and tradition reaffirmed in Bruin. According to Bruin, responsible, law-abiding Americans have the right to carry firearms in public for personal defense. The government's brief emphasized that the Ninth Circuit relied on irrelevant and misleading historical laws, some targeting racial minorities, others tied to long outdated hunting codes, which have no place in serious constitutional interpretation. One of the boldest aspects of the filing was the call for the High Court to ignore the usual hesitation around interlocutory appeals and to take up the case anyway. The brief even hinted at broader issues on the horizon, like bans on so-called assault weapons and limits on magazine capacity, signaling that these, too, are likely to reach the courts soon. Bottom line, this case is shaping up to be a critical showdown. If the Supreme Court agrees to hear it, the outcome could dramatically reinforce and potentially expand the scope of the Second Amendment in a post-Bruin America. Here's the latest update on where things stand in Wolf versus Lopez. Just a short time ago, the state of Hawaii officially filed its response to the petition currently sitting in front of the United States Supreme Court. And as you probably guessed, They're asking the justices to steer clear of the case entirely. Their core claim? That it's simply too soon for the High Court to weigh in. According to Hawaii, the case is still in its early stages. It's centered around a temporary injunction. The evidence hasn't been fully fleshed out, and the written arguments, in their opinion, are too limited for a full Supreme Court review. Essentially, they're telling the court to stay on the sidelines and let things play out further in the lower courts. They're also trying to downplay the urgency by pointing out that there's no current disagreement between the circuit courts on this particular issue, namely, whether a state can block licensed citizens from carrying firearms in public access private spaces. Since there's no circuit split, Hawaii argues that there's no rush to settle the matter from the bench of the High Court. But that's not the only angle Hawaii took. They also went after the Trump-era Department of Justice for submitting a brief in support of the plaintiffs. In their reply, Hawaii calls the federal government's input unsolicited and insists that the Supreme Court should brush it off as irrelevant. They argue that the DOJ's brief brings nothing new to the table and doesn't deserve the court's attention. But here's where it gets contradictory. In the very next breath, Hawaii tries to criticize the Department of Justice for not responding to the second legal question raised in the petition. So which is it? Either the DOJ's argument doesn't matter, or it matters enough that they're faulted for not addressing every single point. That kind of double talk doesn't hold up well under scrutiny. Let's be clear, calling the DOJ uninvited misses the mark completely. That's the whole point of an amicus curiae brief. It's a statement from an outside party that brings added context or perspective. These kinds of filings are meant to help the court consider a broader constitutional picture, and the DOJ absolutely has standing to weigh in on issues affecting federal interpretation of the Second Amendment. And here's the irony. When the Biden administration filed amicus briefs backing strict gun control measures, nobody on the anti-gun side raised a fuss about it. No one called those briefs uninvited or irrelevant. But now that a former administration is stepping in on behalf of gun rights, suddenly it's a problem. That's a textbook double standard, and gun owners across the country are taking note. That said, no matter how strong the arguments may be, there's still one huge hurdle: getting 4 justices to vote in favor of hearing the case. That's the first gate to clear, and it's never guaranteed. The bigger question is whether the Supreme Court even wants to take on another Second Amendment case right now, especially one that's still in what's called an interlocutory stage, meaning the lower courts haven't issued a final ruling yet. Historically, the Supreme Court has been hesitant to jump into gun rights cases unless they're fully resolved at the lower levels. They've already passed on several key petitions involving bans on so-called assault weapons and limits on magazine capacity. So it's entirely possible they might skip this one too, simply saying, let the lower courts finish what they started. That outcome would be disappointing, but not shocking. Still, there's a silver lining. The fact that the Trump-era Department of Justice has stepped forward in defense of the Second Amendment, and done so at this critical moment, shows that there's still serious firepower behind the pro-gun position at the federal level. Hawaii can try to brush off the DOJ's involvement, but when the United States government files a brief, it's unlikely the justices will pretend it doesn't exist. As this legal battle develops, I'll be here to keep you in the loop. Be sure to drop a comment, like the video if you got something out of it, and don't forget to subscribe if you haven't already. And always remember, this country was built by men who carried rifles, and it'll be protected by Americans who still believe in their right to keep and bear arms.